Αγαπητές φίλες, αγαπητοί φίλοι, καλή εβδομάδα. Καλώς ήρθατε και σε αυτήν την τρίτη διάλεξη του δεύτερου κύκλου των διαλέξεων για τη διαμεσολάβηση που διοργανώνει η Ελληνική Ένωση Διαμεσολαβητών σε συνεργασία με τον Οργανισμό Προώθησης Εναλλακτικών Μεθόδων Επίλυσης Διαφορών. Σας ευχαριστούμε πάρα πολύ που είστε πιστοί. Κάποιοι από εσάς είστε παρόντες σε όλες τις διαλέξεις και αυτό αποτελεί για μας μια ενθάρρυνση για να συνεχίσουμε, διότι η οργάνωση αυτών των διαλέξεων δεν είναι καθόλου εύκολη, αλλά εμείς κάνουμε με χαρά αυτή τη διαδικασία, διότι βλέπουμε ότι σας αρέσει και παρακολουθείτε. Από την προηγούμενη φορά ο ομιλητής ήταν Αμερικανός και έχουμε ήδη ανακοινώσει εδώ και αρκετό καιρό πριν τις γιορτές ότι στο δεύτερο κύκλο θα έχουμε αρκετούς αλλοδαπούς συναδέλφους οι οποίοι θα μας μεταφέρουν την εμπειρία τους και θα μπορέσουν να μας δώσουν ανάγλυφα τις διαφορές της διαμεσολάβησης στη χώρα του ο καθένας και στην δική μας. Αυτό είναι εξαιρετικά σημαντικό και σας παρακαλώ ιδιαίτερα να το παρακολουθήσετε με πάρα πολύ μεγάλη προσοχή. Σήμερα ο ομιλητής θα είναι ο κύριος Swanson, τον οποίο θα σας παρουσιάσω σε λίγο, ο οποίος είναι εξειδικευμένος διαμεσολαβητής και εξειδικευμένος δικηγόρος και διαμεσολαβητής στον τομέα των πτωχεύσεων. Θα διαπιστώσετε από αυτά που θα ακούσετε ότι η διαμεσολάβηση στην Αμερική είναι εντελώς διαφορετική και αναφέρομαι κυρίως στην υποχρεωτική διαμεσολάβηση. Θα αντιληφθείτε ότι είναι κάτι το τελείως άλλο από την δική μας ΣΥΑΣ. Λοιπόν, για την Ελληνική Ένωση Διαμεσολαβητών δεν θα σας πω τίποτε σήμερα. Νομίζω ότι μας γνωρίζετε όλοι. Δεν είναι ανάγκη να πάρω χρόνο για να επαναλάβω τα ίδια. Θέλω να ξέρετε ότι είστε όλοι ευπρόσδεκτοι σε αυτές τις διαλέξεις, είτε είστε μέλη της Ένωσης, είτε δεν είστε. Επίσης δεν θα σας πω και πολλά πράγματα για τον ΟΠΕΜΕΔ, τον οποίο γνωρίζετε επίσης πάρα πολύ καλά. Θα σας πω απλά ότι και η Ελληνική Ένωση Διαμεσολαβητών και ο ΟΠΕΜΕΔ ενώνουν τις δυνάμεις τους για να προωθήσουν όσο γίνεται περισσότερο τη διαμεσολάβηση, τόσο στην Ελλάδα όσο και στο εξωτερικό. Η αλήθεια είναι ότι ο ΟΠΕΜΕΔ έχει περισσότερες δράσεις, ομαδικές ας το πω έτσι, δηλαδή δράσεις του οργανισμού στο εξωτερικό από ότι η Ελληνική Ένωση Διαμεσολαβητών, χωρίς αυτό να σημαίνει ότι εμείς ως μέλη της Ελληνικής Ένωσης Διαμεσολαβητών δεν συμμετέχουμε ενεργά σε διεθνείς εκδηλώσεις και δεν παρακολουθούμε φόρα για την διαμεσολάβηση ώστε να ενημερωνόμαστε και να αυξάνουμε κι εμείς τις γνώσεις μας. Λοιπόν, ο τίτλος της σημερινής διάλεξης, όπως είχατε την ευκαιρία να διαβάσετε στην ανακοίνωση, αφορά σύγκριση μεταξύ της υποχρεωτικής διαμεσολάβησης και της ελεύθερης, ας την ονομάσω έτσι, διαμεσολάβησης. Την ιστορία και την εξέλιξη των δύο ειδών διαμεσολάβησης, τα οποία στο τέλος γίνονται τα ίδια. Τώρα θα καλωσορίσω τον κύριο Swanson. Don, hello, welcome in Greece.
Thank you.
Even through Zoom, it is a pleasure to have you with us. And we look very much forward to listen to all the interesting things you have to say, to present to us, and to realize the differences between what exists in the United States, in the UK, as you mentioned, in other countries, and in Greece. We will take the opportunity possibly to tell you some rules regarding mandated mediation in Greece. So allow me now, after thanking you very much again for being here today, allow me now to present you to our participants. I will do it in Greek, if you do not mind. But Sergio can translate for you, so as you check whether I say everything correctly. Λοιπόν, αγαπητοί συνάδελφοι, ο κύριος Swanson έχει ένα blog σχετικά με την πτώχευση και την διαμεσολάβηση. Στο εξής link, Σέργιο, μπορείς να γράψεις στο chat www.mediatebankry.com και θα το δω κι εγώ αν είναι. Και είναι μέτοχος στο δικηγορικό γραφείο Κόλεϊ Τσένσεν PC στην Ομάχα της πολιτείας της Νεμπράσκα. Ο Ντόν έχει εξασκήσει το επάγγελμα με επίκεντρο την πτώχευση περισσότερα χρόνια από ότι είναι πρόθυμος να παραδεχτεί. Είναι πάρα πολύ σεμνός και δεν θέλει να παραδεχτεί την μεγάλη του εμπειρία, αλλά είναι αλήθεια ότι αυτή είναι τεράστια. Σαν σημείο αναφοράς, να σας πω ότι μπορεί να συζητήσει άνετα και χωρίς κανένα πρόβλημα σχετικά με την κρίση, την αγροτική κρίση από προσωπική του εμπειρία. Θα ακούσετε κατά τη διάρκεια της διάλεξης ορισμένα παραδείγματα που θα φέρει από υποθέσεις τις οποίες ο ίδιος χειρίστηκε κατά την κρίση των αγροτών το 1980 στις Ηνωμένες Πολιτείες. Ο Ντόν έχει συντελέσει ώστε να εξαπλωθεί η διαμεσολάβηση αναφορικά με την πτώχευση από το 2011, αλλά κάνει κάθε είδους διαμεσολαβήσεις κατά τη διάρκεια της σταδιοδρομίας του, αντιπροσωπεύοντας συμβούλια, οφειλέτες, trustees. Αυτό θα μου επιτρέψει να το πω στα αγγλικά, γιατί δεν υπάρχει, όπως ξέρετε, ακρεφνής όρος στα ελληνικά, και άλλους. Ο Ντόν είναι ένας διαμεσολαβητής εγκεκριμένος τόσο από τα περιφερειακά όσο και από τα πτωχευτικά δικαστήρια της Νεμπράσκα. Είναι πιστοποιημένος, εξειδικευμένος στην πτώχευση, την εμπορική, ας το πω, την πτώχευση στις επιχειρήσεις από το American Board of Certification και είναι ενεργός στο Αμερικανικό Ινστιτούτο Πτώχευσης. Ο Ντόν έλαβε το πτυχίο του από το Πανεπιστήμιο της Νεμπράσκα το 1977 και από το ίδιο πανεπιστήμιο το 1980 έλαβε το διδακτορικό του. Ο κύριος Swanson θα μας μιλήσει στα αγγλικά βεβαίως. Μεταφράσεις θα γίνονται σε σημεία τα οποία οι ίδιοι έχουμε επιλέξει, δηλαδή μαζί με τον κύριο Swanson επιλέξαμε, του ζητήσαμε να ορίσει εκείνος τα σημεία που θα ήθελε να μεταφραστούν και σας παρακαλώ ιδιαίτερα, εάν εκτός από αυτά τα σημεία έχετε και άλλες ερωτήσεις, να μην διστάσετε να τις θέσετε στο chat. Εμείς τις βλέπουμε και ο κύριος Μαναράκης και εγώ και θα μεταφράζουμε με πολύ μεγάλη ευχαρίστηση ό,τι θέλετε ή και θα επαναλάβουμε και ό,τι θέλετε στα ελληνικά, εάν το επιθυμείτε. Σας ευχαριστώ πάρα πολύ και πάλι για την προσοχή σας και εύχομαι, πραγματικά εύχομαι, δεν είναι τρόπος του λέγειν, εύχομαι να απολαύσετε αυτή τη διάλεξη και να συναποκομίσετε από αυτήν όλα τα μεγάλα ωφέλη τα οποία μπορείτε να συναποκομίσετε. Don, the floor is to you. Thank you again, and you can start whenever you like.
Well, thank you. It's an honor and a pleasure to be with you here today. Mandatory mediation for lawsuit disputes is a controversial concept. The idea that mediation can be mandated by court order or by court rules is anathema to many. That's true in the United States, it's true in Canada, it's true in England, and I assume it's true in Greece as well. I don't know exactly why that is. After all, judges order litigating parties and their attorneys around all the time in a lot of different ways. Why they choose to be bashful about ordering people into mediation I don't understand it, but it exists. The issue centers around the expressed ideal that mediation should be entirely voluntary. That ideal is held by many people everywhere with doctrinaire fervor. The problem with the ideal is this: it is not supported by anything. There are, for example, mandated mediation programs in courts in many systems, and those are highly successful. And there are studies showing that, I'll just read some findings here. Mandated mediation produces settlement agreements. It produces happy results for the parties. It preserves a party's right to self-determination on whether to settle. It minimizes litigation expenses and delays, and it assists the progression of litigation even when it fails to produce an agreement. It, for example, helps narrow the issues for trial. Among judges, it's my observation that that ideal seems to be held by nearly everyone. I don't feel comfortable ordering people to mediate, or mediation should not be mandated, are nearly ubiquitous sentiments among judges. Now, Catherine, do we need to pause for translation or anything here?
I will put the question to the attendees and see what they think.
Είναι κάποιος που χρειάζεται μετάφραση?
Έλα, το στέλνω.
Όχι.
Όχι.
Αν κάποιος θέλει και δεν θέλει να αποκαλυφθεί,
Όχι.
σε μένα
Ευχαριστούμε.
δεν θα πω όνομα.
Είναι πολύ κατανοητός, δεν χρειάζεται.
Ωραία. Να προχωρήσουμε.
Αν πάντως οποιοσδήποτε θέλει μετάφραση, μπορεί να μου το στείλει και σε μένα, θα το δω. Αλλά
Πάντως
προχωράμε.
είναι πολύ κατανοητά τα αγγλικά του, πολύ καθαρά.
Ωραία, ευχαριστούμε. Εάν μετανιώσετε, να το δηλώσετε, έστω και με ένα SMS στο τηλέφωνο του Σέργιου ή στο δικό μου.
Το προσωπικό, δεν σε μένα.
Μην διστάσετε να το κάνετε. Λοιπόν, να πούμε στον κύριο Σουάνσον ότι είναι πάρα πολύ κατανοητός και ότι μπορεί να συνεχίσει. Σέργιο.
Στα αγγλικά όμως.
Σέργιο.
So, Mr. Swanson, you can continue. Everybody understands you.
Yes, they say that your English is very, very clear. They are happy with it, and they do not need any translation, but they thank you for the proposition.
Once again, I'm honored. Thank you. A judge's opposition to mandated mediation, this is my observation, tends to last only as long as caseloads remain manageable. Once caseloads become heavy and overwhelming, judges look about for solutions. And mandatory mediation is one solution that is commonly adopted. In fact, mandated mediation to address heavy caseloads is precisely the reason that today's mediation profession even exists in the United States. Now, today I'm using examples from the United States because that's what I know, and elsewhere to illustrate what I believe is happening everywhere. These mediation experiences are common throughout the world. I don't think that's an overstatement. Details are different, but the essence of what happens seems to be roughly the same. In the US, back in the 1970s, the chief judge of a United States appellate court is facing burgeoning caseloads that result in long delays before cases can be heard and resolved. To address this problem, the judge begins an experiment in which cases are randomly assigned to mandatory settlement conference with a settlement judge. That mandated mediation experiment proves to be highly successful in achieving settlements and reducing caseloads. So it becomes a permanent part of that court's regular processes. Then, its continued success results in nearly all other similar courts adopting similar mandatory mediation process, all of which continues to this day. And what happened in that U.S. appellate court in that experiment is viewed as the beginning of today's mediation profession in the United States. When mediation is not mandated, studies show that mediation programs are often underutilized. And that is when they rely on entirely voluntary entry by the parties. That's true even when caseloads are causing delays and even when mediation is offered at low cost or no cost. And that's true in many countries, not just the US. Small claims courts are a common example. These are courts that deal with small amounts of money in dispute in which individuals represent themselves without lawyers. Many of these courts offer mediation services at no cost. The mediator is doing it as a volunteer, pro bono. And these volunteer mediators are standing by in court to provide on-the-spot mediation. These mediation services are not mandated. And even with volunteer mediators standing idly by in court to mediate disputes immediately and at no charge, their services are underutilized. Now, why don't the small claim judges simply order some of these parties into a no-cost mediation to remedy the problem? I don't know. But they don't, and they won't. And that's a shame. Studies also show that the same is true in other courts with entirely voluntary mediation programs. And in post-trial interviews of the parties in those cases who do not participate in a voluntary mediation, they have no recollection of even being advised by the attorneys or by the court about those mediation services. That is also a shame. Now, there is a study of mandated mediation in England and Wales that lists the following benefits. Number one, mediation is capable of conferring huge benefits, and this is a quote, on disputants and on the civil justice system. Number two, the voluntary use of mediation is disappointingly slow and small. So, requiring mediation even temporarily can, quote, really change the culture. Number three, experienced mediators feel strongly that mediation will be effective in settling a majority of cases and will shorten or help to focus the cases that do not settle. Number four, if you let the parties argue about whether to mediate or not, they will do so. And they will argue generally for tactical/positional reasons. Number five, in mandated mediation, the parties are only obligated to attend and participate in good faith. They have no obligation to settle. Number six, experience shows that parties who attend mediation under compulsion and unwillingly often engage in the process and settle their disputes. And settlement rates did not drop. And number seven, the last one, sometimes parties are quietly relieved when compelled to use mediation. That's because of a sense that proposing mediation might, this is quote, might lead an opponent to suspect weaknesses in their case. Those are the benefits. Now, here are the negatives that are found in that study. And I'll list some comments because I'm obviously on the side of mandated is a good idea. So I want to comment on each of these. The first one, it, quote, taints the voluntary ethos, which is the hallmark of mediation's success. Well, this is a doctrinaire view and is not a practical view. Number two, it, quote, puts unwilling parties into an unfamiliar process, which reduces the chances of succeeding and brings the whole process of mediation into disrepute. My comment, there is no data behind this. Number three, it has to be paid for by the parties or the state, and such costs will in many cases be wasted. My comment, well, what about the ones that settle? There's no waste there. Number four, its costs may well be disproportionate for many types of cases. Even a fee of £100, for example, will be impossible in many small claims cases. My comment, well, what about mandatory mediation at no cost by volunteer mediators? Number five, its compulsion means that any claim, however worth less, will involve expense and hassle, which creates an artificial nuisance settlement value for spurious case claims. This, again, I suggest is a doctrinaire view, not a practical one. Six, its likely consequence, if mandated, is to produce perfunctory box-ticking mediations that go nowhere. My comment, well, what about the ones that achieve settlement? Seven, because of privilege issues, policing a requirement of good faith participation and proving a violation can be enormously difficult. My response, that's true. But what about good faith participations, which far outnumber the bad faith ones? Number 8 of 9, it may be a breach of the party's Article 6 human right of access to the court. I know nothing about that. I have no comment. Number 9, the final one, it may, as a practical matter, end up being imposed upon cases in which there is no real dispute, such as the undefended money claims that make up the majority of claims. My response, that may be true, but we can create an exception for those cases. So in comparing these two lists, the pros and cons, it's striking that the pros tend to be along the lines of mandatory mediation works and provides good results, while the cons are more along the lines of holding on to the ideal with imagined taints and unsuccessful efforts and wasted costs and artificial nuisances that can be remedied by creative action. Now, I suggest that, let me check in once again. Are we still okay with no translation? So I suggest that when ideals confront realities, practical realities, the ideal tends to yield to the practicalities. There is a study by a mediation professional who holds strongly to the ideal that mediation must be entirely voluntary and not mandated. Yet, when she evaluated the data on effectiveness of mandated mediation, developing a mediation culture, she then acknowledged this: once attorneys with no experience in mediation are compelled to do it, they become accustomed to it, like what it has to offer, and start utilizing mediation whether it's mandated or not. That is a practical effect. So she adjusts her position in this study on no mandated mediation to this: mediation can be mandated for a limited period of time to develop a mediation culture. And then, when that mediation culture is established, the mandates for mediation must cease. This is a data-based revision of this professional's ideal to address a practical problem of underutilization when it is entirely voluntary, and getting around that by mandating mediation for a time. Similar experiences and observation by elsewhere have led to creative solutions. That study I mentioned is an example of the tension between the need for mandated mediations and the desire for an entirely voluntary mediation system. The result everywhere is a lot of creative energy expended to bridge and relieve that tension. Back in 2018, for example, a New York state court is experiencing severe caseload problems. As a part of the effort to solve that problem, the court introduces mandated mediation. In a creative effort to minimize its mandated nature, the court creates these two procedures. The first 90 minutes of every mandated mediation will be performed pro bono by the mediator. And then, if the parties wish to continue with the mediation, they may do so, but they will be paying for the mediator's services from then on. Another example of creativity is in British Columbia, Canada. Here's how the mediation program works there. A party to a lawsuit may initiate mediation by serving a notice to mediate to the other parties in the lawsuit. And a mediation then must occur unless one of the parties declines and meets one of the exemption grounds. There are three. 1, mediation has already occurred. 2, the parties agree in writing that mediation shall not occur. Or 3, the court finds that a mediation would be materially impracticable or unfair. These exemptions are very narrow. A case in the Supreme Court of Canada under the British Columbia system found three things. One, applications for exemptions are rare. Two, settlement rates in all forms of mediation, including mandatory mediation, are high. And three, a mediation effort can be valuable even when the parties are unable to reach a settlement, including narrowing and refining issues, planning next steps in court, and shortened trial time. A study of this British Columbia system from England reaches these two conclusions. Number one, the system has led to the growth of informally agreed mediation as a norm, with the formal procedure only being invoked rarely. And number two, this is exactly the kind of outcome we would welcome and would see as beneficial for civil justice here in England. Put another way, the result of a creative and mandated mediation system is the development of a voluntary mediation culture, which is a highly desirable result for everyone. Now, most mandated mediations of lawsuits in the United States arise from court orders in individual cases or as mandated by local rules for groups of cases. There aren't many statutes in the US created by legislatures, state or federal, that mandate mediation for lawsuits. There are some, but they're rare. Federal statutes do mandate that federal agencies use mediation to resolve disputes within their own agencies. And these mandated mediations are highly successful in resolving disputes. But my discussion here today is about mandating the mediation of disputes in lawsuits that are already filed in a court or about to be filed. One example of mediations mandated for groups of cases by court rule is in bankruptcy courts, where I practice frequently. In a single large bankruptcy case, lawsuits might be filed against hundreds of creditors to recover money they received shortly before the bankruptcy filing. Some bankruptcy courts have local rules requiring the parties in each of those hundreds of claims to mediate the dispute before it can go to trial. This approach is viewed favorably and therefore is expanding. One, to other bankruptcy courts, and two, to additional types of cases. Now let's talk about enforcement of the mandate. Enforcement efforts vary widely. Most commonly, enforcement is in the form of money fines for failure to appear at a mediation session. The fine is usually in the amount of attorney fees the other side incurs unnecessarily because of the failure to appear. It's also possible to be fined in a similar manner for appearing, but then failing to participate in good faith. This good faith participation standard is rarely sanctioned because of difficulties in defining exactly what constitutes bad faith participation. This lack of good faith, however, appears to be a rarity. Most parties, the vast majority of parties, take it seriously and comply. Mediation cultures do develop in many communities without being mandated. However, such culture developments can take decades. This is true everywhere. In my local community here in Omaha, Nebraska, for example, we have a strong mediation culture that developed voluntarily on the merits of mediation alone. Mediation has rarely been mandated here. Mediation began developing initially in personal injury cases back in the 1980s. The local courts were backlogged, so plaintiffs and insurance companies for defendants started mediating their cases as a way to move them along. The result is that plaintiff's attorney found they could get favorable settlements without the costs and risks of trial. And insurance companies found they could get favorable settlements without the risk of a runaway jury or the costs of trial. So they began mediating every personal injury case and settled the vast majority. Then, as those personal injury attorneys, both plaintiff and defendant, handled other types of civil lawsuits, they began mediating those as well. Over time, the culture in our community has become this. Nearly every civil case will be mediated voluntarily before it ever goes to trial. In fact, if you talk with local litigators, if you talk with my partners today about their cases and case strategies, the first thing they talk about is getting mediation scheduled and about the results of those mediation efforts. That's before they ever talk about going to trial. But that took decades to develop. On the personal level, here's how I became a believer in mediation. And it's in the context of an entirely voluntary mediation system. This happened more than 3 decades ago. The state where I practiced had passed a new law requiring a creditor to give notice of a mediation opportunity to the debtor before attempting to enforce a farm loan. But there was no requirement to actually participate in the mediation. In representing a rural bank, I gave the required mediation notice, and the debtor in response expressed a willingness to mediate. In advising the bank, I expressed skepticism about the mediation's effectiveness and recommended that the bank use its local rural attorney in the mediation instead of paying me to drive 3 hours to attend. A couple weeks later, I'd forgotten all about this. I'm sitting in my office and the phone rings. I answer the phone and my banker client is on the other end of the line. And he says, "We settled." I'd forgotten what this was all about. And I said, "Settled what?" He says, "Their mediation resulted in a settlement with the farmer." Now, at that moment, I'm shocked and I'm embarrassed because I had suggested it would not settle. But I responded nevertheless with, "That's great." I've never doubted mediation again. But here's a recent example of how that very same and entirely voluntary mediation law is useless. We're operating under the very same state mediation law that I just mentioned. This time I'm representing the debtor, the farmer. And we receive one of those mandatory mediation notices from the farmer's bank. The mediation notice says this, get this, quote, this is a quote. "By providing you with this notice, bank is merely complying with the notice requirements under the Nebraska Farm Mediation Act. Bank does not in any way acquiesce to participation in the mediation process with you." Now, I still can't believe the bank did that. Now, they might think it, but actually saying it? Similar farm mediation laws in other states are mandatory, and are highly successful in producing settlements. But under this non-mandatory law from my state, the bank says essentially, here's notice of your mediation rights, but we won't mediate with you. That's craziness. The moral of these stories is this: a mediation culture can develop without the assistance of mandated mediation, but the entire process is likely to take decades to accomplish, if it ever happens. Similar things have happened in many localities everywhere. But I want to talk some more about benefits from failed mediations. One argument against mandated mediations is this: they produce settlements at lower rates than entirely voluntary mediations. Now, whether that argument is accurate or not, it misses a significant point. The point is this: mediations provide benefits to the litigation process even when they do not produce a settlement. One study finds that non-settlement benefits of mediation include narrowed issues for trial, a better understanding of those issues by the parties, greater efficiencies in the pretrial process, etc. Such benefits are commonly realized whether the mediation was mandated or entirely voluntary. One recent example is a bankruptcy dispute where the parties mediated their disputes over a creditor's claim twice. The two mediations produced no settlement. The dispute goes to trial on some but not all issues, and the bankruptcy judge rules on the merits on those issues. As to issues that remain, the bankruptcy judge mandates a third mediation. The parties comply, and they reach a settlement in that third mediation of all the disputes between them. For these disputing parties, mandated mediation works even after two prior failures. There are also additional benefits of a more general nature. What mediation does is inserts a third-party neutral between disputing parties to help them negotiate effectively. Here's an example of how that happens. Studies show that anger and similar emotions often exist between disputing parties, and that such emotions prevent the parties from accurately seeing the opponent's true position and interests. A neutral mediator can help those parties, one study says, by prompting them to correctly identify their emotions and thereby moderate the negative effects of such emotions. This moderating effect can occur in all types of mediation, including both mandated and entirely voluntary. So that is the substance of my prepared remarks. I thank you for your time and attention, and it is my pleasure to visit with you today.
Thank you very much, Don. It was a big pleasure for us to have you with us. And I would like the participants, if they have no objection, to put questions, because we have many questions to put in comparing the mediation, the mandated mediation as you have described it, and the mandated mediation in Greece. So let us start, dear participants. Έχει κανείς καμία ερώτηση? They have understood everything. You were so clear that everything was understood. Still, I would like to put some questions, if I may. Αγαπητοί συνάδελφοι, δεν θέλετε να ρωτήσετε κάτι?
Κύριε Θοδωρή, θέλετε να την πείτε, να την διατυπώσετε καλύτερα?
Μάλλον ναι, θα ήταν προτιμότερο προφορικά.
Πες την κατευθείαν στα αγγλικά. Ναι.
Okay. Dear Mr. Swanson, thank you very much for all the very interesting experience you shared with us. And I would kindly like to set a question. Here in Greece, so far, it seems that most denials or objections against mediation in general, not only mandated, but also voluntary mediation, comes from lawyers. At least this is my experience. So, due to your experience, what would be your advice in order to confront or settle down these objections or denials from lawyers to mediation? Thank you. Thank you very much.
Well, very, very good observation. That what you have said is the impediment comes from lawyers themselves has been true in my experience. Let me give an illustration here. I talked about how in my local community, mediation developed just kind of naturally without mediation over a number of decades. That was true in civil litigation in what I call regular courts. Now, I'm distinguishing that with bankruptcy court. Bankruptcy courts, where I practice primarily, have been late adopters of mediation. And it was in January of 2011 when there was a meeting between the bench and bar, that's with the judge and the lawyers, in the bankruptcy court here in Omaha. And we got to the end of the meeting and the judge says, does anybody have any questions? I raised my hand and said, why don't we do mediations here in bankruptcy court? So next thing I know, I'm chair of the Nebraska Bankruptcy Court Mediation Committee. And so I get a group together of lawyers representing different parts of the bankruptcy system. I get a couple of mediation professors from our local universities, and we develop local rules on mediation in bankruptcy court. The judge is very supportive, and he adopts those rules. And so we start trying to do it, and I was shocked that at the pushback we got from the local attorneys. I mean, some of them said, we're not going to do this. And I think they do it in state court all the time. Just go talk to your partners. They'll tell you they're doing this all the time. But there is heavy resistance. And so, but you know, the judge was supportive, and he would mandate a case to mediation every now and then. And what happened is, as the attorneys started doing it, they started getting on board with the system. And some of those, I thought it was really funny. I mean, I chuckled to myself, but those early attorneys who were adamantly opposed to it, once they did a couple, all of a sudden they became the ones saying, okay, let's mediate. How about mediating? And that is generally how it works. So when you say to me that the resistance comes from attorneys, I say, yep, that's exactly right. And the only way to get around that is to do it. And how to start doing it, that is the question. And in our bankruptcy system, we had a supportive judge who adopted local rules. We had one of those cases where there were 150 preference lawsuits filed in one case. And so he set up the rule at our request. He set up the rules for requiring mediation of those before they could go to trial. And, you know, it's just a supportive judge requiring people to mediate, and it happened, and it just then developed naturally, just like that one, I mentioned that study by that mediation professional who was against mandatory mediation. Well, when she looked at the data and the history, she realized, well, that's how you get it started. So you mandate some, and that gets people comfortable with it. They start doing it, and then you have a voluntary system. But great question. You nailed it, I think. You nailed the issue. How to solve that issue? That's a good question.
May I put a question?
No.
Don, if I have understood correctly, at the very beginning, the courts in Nebraska mandated mediation, which was conducted by a judge. Is it so?
Not in Nebraska. The mediations that have been mandated in Nebraska have primarily been with private mediators. Now, if you take our bankruptcy system, it's unusual. Across the country, there are a lot of judicial mediations now happening, but it's a function of caseloads, and so bankruptcy, you know, in market-driven systems, there tends to be ups and downs. Sometimes the economy is great, and other times it's not so good. So when the economy is great, there's not so much bankruptcy work, and the judges aren't as busy. When the economy is poor, they can't keep up. And so what happens is, during the time when the economy is pretty good, and in the US, it's been pretty good for a dozen years or so now. And so the judges aren't quite so busy, and so they love to do mediation. And so their judges refer mediation cases to each other. But you get into a time when prior to that, there was some, you know, over my career, there have been a lot of downtimes. And during those downtimes, judges are scrambling to keep up their caseload. And in those times, if one judge says to another, I want to refer a mediation to you, they said, no, I can't do that. And so then private mediators tend to do the lion's share there. And so it can be either way, but when judges, let's put it this way, when judicial caseloads are heavy, that's when mediation thrives. When caseloads are light, not so much.
I see. Thank you very much. Very interesting. And I have another question connected to the previous one. Private mediators, what do they have to have in order to become mediators? Have they to be trained? Have they to present exams? Have they to be successful in the exams? Or are any other formalities needed?
Well, that varies widely among the various courts. If you, there are 50 states, and every state could have dozens of courts. In the federal system, there are 94 judicial districts, and every one of those can have a different system. And in the federal system, for example, there are district courts and there are bankruptcy courts. Those are just two examples. And they can each have different systems. So everything, and then some, California will require one level, Nebraska requires another, but mostly it's pretty heavy. A common thing is we have a 40-hour, there are 40-hour mediator training courses. And those are usually commonly required for entry. What's required after that in terms of continuing education varies widely, and I'm not familiar with many requirements of passing a test.
I know there are no requirements to pass the test.
No, not that I know of. But here's what happens in, at least in my experience, is that there tend to be a few mediators who get a reputation of being very effective, and they tend to dominate the system. And so the ability to enter, the entry ability for other mediators is very difficult. And usually that requires coming on, through some volunteer system where you get experience and develop an entry into the system that way. Otherwise, there tends to be a dominance of the entirety by a few professionals. Now, I want to give an example here of something I've been doing recently that is related to that. And oh my, now that I got into this might require more explanation, but there is a new bankruptcy system in the United States for small businesses. That's for businesses with less than 7.5 million of debt. Before, in the bankruptcy system, they are governed by the same rules as General Motors, monstrous companies that are publicly owned. We're talking about privately owned businesses where the owners and are the guarantors, and they are the business. And so I've been appointed as a trustee for those cases. And one of my duties is statutory duties is to help develop a consensual plan of reorganization. So I basically, as soon as a case is filed and there's a meeting where all the creditors get together with the debtor and ask questions, immediately follow that, I set up what I call a facilitation meeting. And what it is, it's a Zoom mediation. And the agenda is, okay, the debtor starts out talking about, here's our situation, here's our plan of action for dealing with this. And the second item on the agenda is creditors. It's all joint session, by the way. The creditor responds with, here's where we see skepticism. And then we have the third item is how we might approach a consensual arrangement. Now, that is an entirely new deal where, it just gave me an opportunity to do a mediation type of thing. And I've taken advantage of that, and that's been pretty successful. And there is an example of how a person can just take something new and creative and develop a mediation type of system out of it. But otherwise, the barriers to entry are pretty high.
Thank you very much, Don. If I may, I would like to tell you how things went in Greece.
Thank you.
Regarding the interpretation that mandated mediation could harm Article 6 of the Human Rights Convention, because it was surprising but true. In Greece, mandated mediation for the first time was introduced in our legislation in 2018. The Athens Bar Association and other bar associations filed a petition with the High Court asking for their opinion whether such mandated mediation was constitutional or not. The answer at the end of the day was that it was not constitutional. The difference of votes was very little, 17 in favor of the constitutionality and 21 against. And the main reason which was invoked was that mandated mediation prevents or at least makes more difficult the filing of the claim with the court because of the expenses which would be occurred by mandatory mediation. And thus, it was rejected. Now, in the law of 2019, we have articles providing for mandatory mediation in 6 categories of cases, and it has been declared constitutional because the fee of the mediator is very low. It was 6 to 50 euros divided by 2, because it is taken in charge by the 2 conflicting parties. And the fees of the attorneys, because the presence of the attorneys is mandatory, they are freely agreed between the clients and the lawyer. This has nothing to do with mediation. And thus we have the mandatory first meeting of mediation before a lawsuit is heard in court in these 5 very large categories of cases. I think there is a question.
Oh, if I may respond, that is that's absolutely fascinating. Yeah, thank you for that.
You're welcome. Υπάρχει καμία άλλη ερώτηση, Σέργιε?
Όχι, δεν βλέπω ερώτηση. I would like to say something, Don. One of the ideas you said that works there is that you have a 90-minute pro bono mediation session, and then the parties decide whether they will proceed to a normal mediation or not. This is similar with what we have here in Greece. We don't have mandated mediation as such, but we have a mandated first session of mediation. In some cases, the parties are obliged to attend to a meeting like that, which is not time limited, it's not 90 minutes by the law, but in practice about 20 to 30 minutes, during which the mediator has has obligation to inform the parties about the mediation. Technically, it's not a mediation, it's a kind of mediation. And at the end of this, the parties actually decide whether they will proceed or not. So I think it's almost the same. And what our experience has shown here the last about a year that this mandatory first meeting is in order, is that many cases have, in many of these cases, the parties actually decided to proceed to mediation. And this is the one. And the second, that to my opinion is the most important, is that this is the only actual and the real way for the parties to be informed about mediation. Because the lawyers have by the law the obligation to inform parties that there is also this method of resolving disputes, but in fact they do nothing. So in this way, they are obliged to do that. So after this introduction, I would like to ask you how this 90 minutes mediation has worked in the States.
You know, I have not read anything. I have no experience with that, and I haven't read anything on it. But my impression is that that would be very highly effective. Just based on my experience and things I know, you know, particularly at the beginning of a case. I think you said your thing happens before the lawsuit is filed.
Not necessarily, but okay. It can be done before the lawsuit is filed.
Okay. Yeah, that strikes me as very, very effective. You know, one of the things studies show is that early mediation tends to be more effective than late mediation late in a lawsuit. How it happens around here in my locality is a case is filed. This is the standard way. This is how it happens. Lawsuit is filed. go through the discovery time where you're trying to get all the information together. And then when that discovery time is about getting ready to conclude and before trial, that is when mediation occurs. And one of the things that drives people to settle is they've been paying fees. You've gone through the major part of the lawsuit and all that's left is the trial. You've gone through all the discovery disputes, you've expended all that time, and you just have weariness. They have fee weariness, they have fight weariness, and people, that's an opportune time to settle, and it settles most times. But actually that is an inopportune time to settle, because studies show that once you start getting contested litigation going, every contested motion that's filed and addressed by the court, everybody's position gets a little more hardened, and it becomes more difficult to settle. So when you're talking about an early mediation session or one before filing, that is an opportune time when the parties are in the best position to settle. I've got a case going right now where before this, it's a bankruptcy case, and before the bankruptcy was filed, the parties were very, very close to settling, but they couldn't get it done. And mediation was not utilized, but we got pretty close to it. But then the litigation wore on, and as the litigation wore on, the positions became hardened, and the possibility of settlement evaporated. And it's only as you start getting the judges making rulings on these things and narrowing this back down where everybody can see where things are that the possibility of settlement even exists. Now, again, they came very close to settling early on. Litigation hardened things, and it's more difficult to settle now. So all of that in response to your question about 90-minute pro bono. But my guess is that that will prove to be very effective. And it'll probably prove to get a lot of settlements within 90 minutes.
Okay, thank you very much.
I have another question, Don, if I may. You mentioned as an example that in a specific case, there have been 2 mediation attempts which failed, both of them. The parties went to court, and the court has ruled on the merits, but the judge on some of the merits. The judge ordered mediation, the parties went to mediation, and then they have all their disputes, all the points of their disputes solved. Did you mean that when going to the 3rd mediation, the parties could solve all the issues, even those which had been solved by the court?
Yes, and the reason is because the right to appeal doesn't happen until all the issues are solved. And so there is still an appeal right. And so the judge's ruling is not final. But the parties now know what this judge will rule. Now, what an appellate judge will do is another story. But the parties now know what this judge will do on some of the issues, and then they can evaluate all the other issues together. And so what happened is the parties got together and they solved all the issues. I don't know whether they simply adopted what the judge said, or if they modify it saying on appeal we're going to win, and so it should be this. And but what happened is they did a global settlement, as we call it around here.
I see. So including the issues which have been ruled by the court.
Yes, and the reason is because there's still an appellate right, a right to appeal from that. So it's not a final ruling. It's just an indication of what the judge will do.
Very interesting. Thank you very much. Αγαπητοί συνάδελφοι, άλλη ερώτηση? Άλλη ερώτηση?
Δεν βλέπω κάτι.
Όχι, ευχαριστήσεις, βλέπω. Διάβασέ το στον Don.
Don, you have congratulations for many of the participants. Maria Torori, thank you. Vicky Ladaki too. And I believe almost everybody has the same opinion, including me, of course.
Including me as well.
Well, thank you. You're most kind. And it truly is an honor and pleasure to be with you here.
Thank you very much. And please take advantage of our invitation. When COVID-19 is over, please visit us. It will be a pleasure for us to welcome you and to show you our country and its beauties.
I'd love to come back, you betcha.
Thank you very much again, Don, for having accepted our invitation. We wish you all the best, many, many successful mediation, and be well and keep in touch. Thank you very much.